Sarawak is both poor and underdeveloped as it emerged in 1946 after World War II, from a century of rule by the White Rajas, who, whilst enlightened in terms of social relationships, displayed a chronic neglect of education and the rudimentary framework for development. There was no recorded budgetary expenditure on education prior to 1939. British colonial rule did affect considerable expansion of education, established a basic infrastructure and instituted a measure of development planning. As of 1963, educational budget absorbs nearly 15% of total government expenditure. With the current conditions of education in Sarawak, which was lacking in many sides in terms of performance and facilities needed, understanding of our rights must be taken into urgent consideration before we can take the necessary actions to rectify the issue and problems. Therefore, Sarawak government must take serious action to empower the state with proper legislative and jurisdiction authority over education in Sarawak. Here, Sabah and Sarawak government and their representatives in parliament must play a big role in participating and formulating policy of the new education as intended by the Federal Education Minister. During the new Policy Council meeting on education, the representatives of Sabah and Sarawak must insist on our rights in education as entailed in paragraph 3 of IGC report, which acknowledge that education is one of the safeguards for the special interest of Sabah and Sarawak, and also mentioned in joint public statement issued by the British and Malayan governments on the 1st of August 1962. It is known that education, item 13, fall under federal list set out in the 9th schedule of the Federal Constitution. Under Article 74(1) of the Federal Constitution, Parliament may make laws with respect to any of the matters enumerated in the federal list. Therefore, the federal government are responsible with the standard and progress of education in Sarawak as a whole. Education under federal list also mean that the financial burden of education is the federal government responsibility. To give the effect of laws for the educational rights of Sarawak, the Parliament of Malaysia either through Dewan Rakyat, Act of Parliament, Dewan Negara, Act of Parliament, or Order of the Yang di Pertuan Agong may make laws for the purpose of implementing educational rights of Sarawak as spelled out in the IGC report. This can be done through Article 169(c) and Article 76(1)(c) of the Federal Constitution. Article 76(1)(c) express that Parliament may make laws with respect to any matter enumerated in the state list, but only as follows, that is to say, c. if so requested by the Legislative Assembly of any state. By using Article 76(1)(c), read together with Article 169(c) of the Federal Constitution, the Legislative Assembly of Sarawak may pass a bill to request the Parliament to implement the agreed terms in paragraph 17, Education, and item 13 of Annex A in the IGC report. Article 169(c) expressed that the IGC report entered on the 27th of February 1963, which is before Malaysia Day, shall be deemed to be a treaty between the Federation of Malaysia and the Borneo states of Sabah and Sarawak. Therefore, under Article 76(1)(c), read together with Article 169(c) of the Federal Constitution, the Legislative Assembly of Sarawak can request the Parliament to make laws for the purpose of implementing educational rights of Sarawak as provided in the IGC report. The Parliament may create Education Act, Sarawak, to give effect to the agreed terms in education as set out in the IGC report. Then, the Parliament can devolve the legislative rights on education to Sarawak through devolution settlement mechanism by order of the Yang di Pertuan Agong as provided in Article 95(c), power by order to extend legislative or executive powers of states of the Federal Constitution. These provisions were added by Malaysia Act 1963, number 26, section 38, in force from the 16th of September 1963. Article 95(c) provide the Yang di Pertuan Agong may by order, 1. Under Article 95(c)(1) of authorizing the legislature of the state to make laws as mentioned in Article 76(a)(2). Under Article 95(c)(1)(b), for extending the executive authority of the state, and the powers or duties of any authority of the state, as mentioned in Clause 4 of Article 80. Order of the Yang di Pertuan Agong under Article 95(c)(1) of will provide for the Parliament to authorize the legislatures of the states or any of them, subject to such conditions or restrictions, if any, as Parliament may impose, to make laws with respect to the whole or any part of a matter enumerated in the federal list. This means, Article 95C, 1, provide for the transfer of the federal list into state list. This is simply a devolution of power from federal laws into state laws. For example, when the state government have enough competency to take over education which is now under federal list, by means of the order of the Yang di Pertuan Agong under Article 95C, 1, of the legislation jurisdiction over education can be devolved from the federal government to the state government. Article 95C, 1, provide a mechanism where the ninth schedule of the federal constitution can be modified by an order of the Yang di Pertuan Agong, subject to the agreement of both the federal government and state government. The agreement between the governments concerned would mainly involve the funding mechanism, public services, etc. before the transfer of responsibility was done. Afterwards, Article 95C, 2, enables the amendment or to repeal an act of Parliament passed after Malaysia Day, where that is considered necessary or expedient in connection with other provision made by the order. Procedurally, under Article 95C, 5, the draft order of the Yang di Pertuan Agong under this article shall be laid before each House of Parliament before it can be implemented. The same procedure is required for extending of the executive authority of the state, and the powers or duties of any authority of the state for any specified provisions of federal law being transferred into state law through Article 95C, 1b. This is how devolution settlements between the federal government and state government should works in the Federation of Malaysia, as the provisions to do so already incorporated as Article 95C of the Federal Constitution based on Malaysia Agreement 1963. This is one of the mechanism for devolution settlements on how the federal government and state government can retain flexibility to adjust the devolution of power settlement without recourse to primary legislation. Constitution Amendment under Article 159. The entanglement of education which was under federal list but subject to the provision and condition given in IGC report need to be expressed constitutionally based on various method as mentioned above. Most of the legislative function on education might fall under the jurisdiction of federal government, but the devolution of power on some of the function derived from the education rights of Sarawak in the agreed terms also must be observed properly to ensure that the special interest of Sarawak can be implemented by all of the governments concerned. This is to ensure that the legislative function of each government on education can be adjusted and settled in a better constitutional order without the need for litigation. There might arise some issue on which the legislative function may step into the categories of federal list and state list, which is not beyond the capabilities of both governments to resolve. A further deliberation will then be needed on the borderline issues such as employment and financial responsibility, which actually has been provided in IGC report and Malaysia Agreement 1963. A proper mechanism must be constructed to address this issue, especially in terms of policy differences and competency of the federal and state government agencies in discharging their responsibility on certain function related to education. To this effect, it is preferable for the federal government to pass Education, Sarawak, Act to define the power reserved to Sarawak government as set out in Malaysia Agreement 1963 and IGC report.